Is Judge Veronica Galvan. She's a Superior Court judge. She graduated from the University of Washington School of Law in 1994. She previously served as an assistant city attorney for both the city of Seattle and the city of Federal Way. She was born in Bremerton, but was raised in the Yakima Valley, where her father picked fruit for a living. She was the judge of the Des Moines Municipal Court, where she implemented the only Spanish language court in Washington. Between 2014 and 2021, she received 4 awards for her service and for her dedication to the community. Her topic today is being mindful of diversity, equity, and inclusion. She is such an amazing woman with a very meaningful topic. I was not able to come up with anything funny to say about her or her presentation. Believe me, I tried. To paraphrase multiple public defender clients, if you were a real stand-up comedian, you could have.
Thank you. Well, good afternoon, everyone. Today, as indicated, we will be discussing diversity, equity, and inclusion. As we go through this presentation, I want to note a couple of things. As I explained earlier, this is typically a 3.5-hour presentation that I give to judicial college judges who are starting in their careers, and it just touches upon these topics. This is certainly not the end-all be-all, and I hope that for those of you who are aware of these issues, that it sparks even more curiosity. For those who may be new to these issues, that it also sparks a curiosity and makes you interested in the work that we do and the impacts of these issues on the work that we do. So, without further ado, let's get started. What is it when we talk about diversity, equity, and inclusion? Diversity is pretty simple. It is the presence of differences. But we're talking about a lot of differences between people, but socially there's certain differences that really have social meaning. And I like to formulate these in a couple of ways. There's identities and social issues that provide opportunity, and on the flip side are also used to provide oppression. Dr. Leticia Nieto, who's a local sociologist, really identified 7 areas where we see this happen. Color, religion, gender, sexuality, ability, citizenship, and economic issues. Notice that one word that you're not going to find in there is race, because what we view as race is often based upon, frankly, the color of a person's skin. There is no biological differentiation between people in terms of the race. There's only one race, and it's the human race. What we often deem as race are values that we assign to people's culture, to people's identity, to people's color, and we assign these values and we assign these things to that. So here in the United States, socially, color has been used to assign social value to people. And we have people who, because of the color of their skin, have been affirmatively kept out of certain opportunities. Religion is another issue that we assign social value to. Gender, sexuality, ability, citizenship. I always like to share with people that a lot of times we don't see these things in ourselves. We may not realize the opportunity that we've had based upon any of these items and the opportunities that have been denied based upon any of these items. I'll give you an example. I was born in Bremerton, Washington, and I love sharing the story of how my dad picked fruit for a living and how I ended up going to school and how I worked my way through college, I worked my way through law school, and here I am, voila, you have a judge. And as I was sharing this story at my former alma mater, Pasco High School in Pasco, Washington, I had a young lady afterwards who came up to me. This young lady was brilliant. She was going to be valedictorian. She's top of her class. And she says, you know, you and I share a lot. of similarities. My story is similar to yours. My father picks fruit for a living. This is where I'm growing up, here in the same place you grew up. But I can't go to college because my family can't afford it. And because I'm not a U.S. citizen, I'm not eligible for certain programs like financial aid. And then it kind of really hit me. Like, I don't wake up every day thinking about all of the opportunities I've had just because I was born here, because my mother was born here, because my grandmother was born here. I never think about that. It's like I'm swimming in the water and I've never not had to breathe from that perspective. And so it suddenly hit me that I was extraordinarily privileged, and I was able to access something because of that privilege, not because of merit, not because it was earned, but I was able to access an opportunity, in this case financial aid, that allowed me to leverage whatever abilities I had, go to college, work hard, etc., etc., etc. Like, we all like to think, well, it's meritorious. And in that case, it wasn't. It was because of where I was born. That's what privilege is. It's something that's unearned. And yet we give it a social meaning that's very important in this society. And I know people don't like that word, but that's exactly what it is. And when you acknowledge your privilege, you don't have to do anything. You don't have to apologize for it. I've never been apologetic about the fact that I was born here. But you need to acknowledge the extent and consequences of your privilege and remain aware that people who are different from you move through and experience the world in ways that you know nothing about. Aside from diversity, we always also like to talk about equity. And I very purposefully want to make sure that we all understand that equity is very different from equality. And when we're talking about equity within the context of our work, we're looking at processes, procedures, policies, how we distribute resources in an effort to minimize or completely get rid of disparities in the outcomes for the people that we serve. This is what we're talking about. And when we talk about inclusion, we talk about that as an outcome that ensures that those who are diverse actually feel welcomed within the institutions, or in our case, certainly within the decision-making processes. Because of how I was raised and in my culture, I love stories to give examples. And I always like to talk about equality versus equity from the perspective of being in coach class on an airplane. I am 5'2" on a good day. Coach class, in terms of legroom, has never bothered me. But for somebody who may be 6'3" or 6'4", that may be very different. But equality is both of us sitting in the same seat. Equity is both of us being able to ride at the same level of comfort. So that's kind of how I differentiate it. It helps me to be able to visualize those things. And perhaps that'll help you too when you think about it next time you're in coach class on a plane. It's about ultimately opportunity versus outcome. I told you earlier that when we talk about race, and today, because I have an hour, I'm going to focus on race, and I don't want to insinuate that there are no other areas of disparity, that there are no other areas of diversity. There aren't just as important. There are intersections for many people. Many people aren't just one. You know, for example, I'm a woman and I'm a woman of color. There are people who are disabled and immigrants and people of color, and you know, they may be LGBTQ. So there's a lot of these intersections that we have to be aware of. But regardless, within those intersections, race is often one of those things that makes a marked difference into how those intersectionalities interact. For example, my brother is transgender, and as a person of color who's transgender, his experience has been markedly different than people who may be white and transgender. So I'm going to talk about race, and I just want you to know that it's because of that overlay over intersectionality, as well as the time that I have today. So when I talk about entering the matrix and talking about deconstruction, I'm talking about how we've constructed this idea of race. That this idea of race is somehow a way to differentiate each other as humans. And often a proxy for race is skin color. We're going to talk about how this differentiation has essentially led to us developing, frankly, many biases. Some of them are overt and conscious, but some of them, and many of them, are implicit and unconscious. One of the things that I want to make sure that we all are aware of is whether a bias is implicit or explicit, whether it's unconscious or conscious. The impacts of those biases are still harmful. But we have to acknowledge that bias is a natural part of human nature. We want to identify kind of how we see implicit bias working. And we want to illustrate how it has impacted us as a society. So at this time, I'm going to have you do the following. In your chat, I'm going to show you a slide. In your chat, I want you to write down words that come to your mind. There are no right or wrong answers, just words, just descriptors of the next slide. The first thought that comes in your mind. Don't hit enter. At the very end, I'm going to ask you all to hit enter at the same time so we have a waterfall. And in that way, we really aren't, I'm not looking for attribution of words, I'm looking for descriptors. So again, no right or wrong answer. I'm going to give you all approximately 30 seconds. Again, don't think, this is just brainstorming. Just write whatever comes to mind. Okay, I'm going to go through these words. Homeless, poor mental health, cold, disadvantaged, forgotten. Poor, male, sad, resourceful, homeless, poverty, destitution, bad luck, sadness, hopelessness, sympathy. Bad luck, destitution, sympathy, lonely, poor, humble circumstances, unhoused, poor, cold, tough day, poor, homeless, dirty, destitute, sad, sadness, despair, depressed, frustrated, angry, sad, lonely, cold, drunk, angry, lost, sad. The reason I'm showing you this is because in approximately 35 seconds, we've already identified somebody just by looking at them that has perhaps some substance use disorder issues, right? Somebody described him as drunk. People have described him as mentally ill, sad and depressed, unhappy, despairing, homeless. And those are just the immediate things that come to mind when we see that picture. Now, if I sat there and told you that this was a picture from a movie set that they were filming, think about how quickly your thought pattern shifts. So this is how unconscious bias works, right? This is our brains essentially thinking about what is this and how am I going to have to decide whether I'm going to have to deal with this issue, react to this issue, respond to this issue. How is this going to affect me as a human being? So that's kind of how our biases work, right? It's our brain working to make sure that it interprets the world around us, frankly, to determine whether or not I'm in a situation where I need to engage in fight or flight. But when we talk about bias, what we're talking about is an unfair preference for or dislike for something, right? Again, we talked about explicit. That's very, very easy. It's me letting you know exactly how I feel. We're talking about implicit, which is that unconscious level that we may not even be aware of, despite any good intentions. We have individualized bias, which is where we see individuals have biases against other individuals. We see institutionalized bias, right? When you think about in terms of institutions, the court is an institution, police are an institution, your agencies can be institutions. So we think about institutions that implement policies and procedures that, while facially neutral, may actually create disparities in outcomes. And we look at structural bias. Structures are made up of institutions, right? For example, the legal system is made up of several different institutions. And as a structure may together, in collaboration, whether intended or not, create outcomes that cause for disparate treatment. Biases are often unconscious, unintended, and implicit. And biases manifest themselves even amongst individuals who at the conscious level reject stereotyping and prejudicial behavior. And bias impacts all of our behavior. Let's go back to that slide that we saw. We think about, again, how we just immediately categorize things and put things into categories because this is how we're used to seeing them. This is how the world works. This is what we see. This is what we've been essentially programmed, frankly, to do. How does this happen to us? There's a science behind it, and scientists have been studying the bias for a while. And they've determined that our biases essentially come from the amygdala, which is the integrative center for emotions, emotional behavior, and motivation. But who are we most likely to prejudge? And that's when there's just ambiguous stimuli, when we want to fill in the blank because there's something that we don't know about. This is what I have deemed what I call Sesame Street conditioning. Don't get me wrong, I love Sesame Street. It's one of my favorite shows of all time. But when you think about it, you think about these things belong together. This is not the same. It's always, how do we know how to engage with something that we're not familiar with? Is this something that we're going to have to engage in flight from? Is it something that we are going to have to fight for? Now, if you think about how much, and again, visually, audially, through all of our senses, we make judgments based upon what we feel, see, think, hear, how that works and how we are fed information that continue to support our notions, our ideas, our beliefs. Filling in the blank when we don't know something about somebody becomes a very easy thing. This is how we develop stereotypes. This is how we develop shortcuts in our thinking. And these shortcuts in some situations serve us well because our brains are saying, if this is the situation, this is how I need to address it. If this is the situation, this is what I need to have done. Those shortcuts are created so that we can be efficient in our decision making. And again, this is a very human thing to do. We need to know, is this thing going to be something, again, I need to engage in fight or flight from? How do I protect myself? How do I ensure my own safety? How do I engage in this unknown quantity? And that's where some of these dangers lie. So I'm going to show you a series of pictures just so you can kind of visualize, again, a series of pictures in which people are kind of, in many ways, not engaged in the ways that we typically see them. This was part of an art show, and it was extraordinarily shocking for many people to see these pictures because it kind of laid out for them how we see things and where people belong in our own society. And these pictures are important because they kind of juxtapose what are very common conceptions about where people work, where people live, and how people see themselves. It's hard to be what you cannot see. So when people do not see themselves reflected in certain areas and certain worlds, it may be hard for them to find legitimacy in those institutions or in those structures that they are engaging with. This is one of the reasons that things such as diversity is so important. In terms of studying bias, a lot of the studies that took place were based upon crime and criminality. One of the most famous studies talked about subjects that were primed with black male faces, in other words, shown pictures of black male faces, white male faces, or no faces, were asked to complete an object recognition task. There was a hypothesis. If the Black Crime Association impacts our visual perception, then participants primed with black male faces would more readily identify crime-relevant objects than those primed with white male faces, which essentially means that they showed pictures and then they showed objects that might be relevant to what people would perceive to be criminal conduct, such as a weapon, a firearm, a knife, etc. Well, their hypotheses, they believed, would be also show no difference when shown non-crime related objects. So the results. The exposure to black male faces facilitated recognition of crime-related objects. That means that people were more easily identifying guns, knives, in terms of timing when they were exposed to black male faces. Exposure to white male faces inhibited the identification of crime-related objects, something that they weren't necessarily expecting. But again, because of how we view things such as crime and criminality, how we are primed for that through media, through programming, through rhetoric, through newspapers, even though statistically incorrect, this essentially foments some of the biases that we continue to perpetuate. To give you an example, I'm going to ask you once again to go to your chat box. And I'm going to ask you, and this is a free chat, you can just enter as soon as you think of a word. Just tell me what this person's doing. You pull up my chat here. Okay. Cleaning trash from body of water, swimming across with belongings, migrating to safer place, carrying belongings, cleaning trash from body of water, standing in water, crossing from Mexico, escaping a flood, waiting. Okay. So that's what they're doing. So this was what they were doing, was the same thing. And yet, when we look at how these actions were described, let's look at it. 2 residents wade through chest-deep water after finding bread and soda from a local grocery store after Hurricane Katrina came through the area in New Orleans. A young man walks through chest-deep floodwater after looting a grocery store in New Orleans on Tuesday, August 30th, 2005, floodwaters continued to rise in New Orleans after Hurricane Katrina did extensive damage. So what do we see? Same action, different attributions. We see that the very act of survival is made different because of people's color. And we are constantly bombarded with this, right? The very act of survival is criminalized in the instance of this young man, whereas the very act of survival is an act of heroism on the other side. So what do we do about this? How can we, as people who work in the judiciary, address some of these biases? Well, there's also studies on that. So one of the things that we can do, for example, is called stereotype replacing. This strategy involves replacing stereotypical responses for non-stereotypical responses. Using this strategy to address personal stereotyping involves recognizing that a response is based on stereotypes, labeling the response as stereotypical, and reflecting on why the response occurred. Then you can consider how the biased response could be avoided in the future and replace it with an unbiased response. So this can be used when you're looking at media stories and what you might feel to be a stereotypical response. Another is counter-stereotypic imaging. This strategy involves imagining in detail counter-stereotypic others. These others can be abstract, famous or non-famous. This makes positive exemplars salient and accessible when challenging a stereotype's validity. Another strategy is called individuation. And you see this strategy also play out in the media. Again, particularly, and I'm going to use as an example, color. When somebody from the BIPOC community engages in behavior that is negative, oftentimes that behavior is attributed to the BIPOC community at large. In other words, that one individual represents the community at large when it comes to negative behavior. And yet, oftentimes, when it comes to positive behavior, that one individual from a BIPOC or marginalized community is held up as an example of non-stereotypical actions and an example of how this individual is so different from the larger community. Both are very, very wrong. You have the opposite sometimes vis-a-vis the majority community, in the white community. If, for example, an individual commits what would be deemed to be a non-stereotypical crime, such as engage in criminal conduct, they're a lone wolf. They had these issues. This was not something that we see in our community. This is very different. And yet, any positive attributions of that community is attributed as meritorious to the entire community. This is, frankly, how this country has run for many, many years. That's how we attribute things, as opposed to saying each human is an individual and each human is entitled to succeed or not on their own merit, on their own actions. Not every human being is a representative of an entire community. So individuation is a strategy that relies on preventing stereotypic inferences, whether positive or negative, by obtaining specific information about group members. This helps people evaluate members of the target group based on personal rather than group-based attributes. Another way we can combat bias, perspective taking. This strategy involves taking the perspective in the first person of a member of a stereotyped group. Perspective taking increases psychological closeness to the stigmatized group. It ameliorates automatic group-based evaluations. Another, and I think probably even more important, is increasing opportunities for contact. It's very easy to get lost and socialize with people that look like you, that have your same experiences, that are in that bubble around you. And when you do that, you kind of lose the ability to, number one, learn more about your fellow human beings, and expand your own experiences, your own perspectives, and your own lenses. Truly, the beautiful thing about diversity, and I see this in the work that I do every day, when I have 12 jurors who all view the same thing, who all come from different walks of life, have different lenses, apply their perspectives and their lens to the evidence, collaborate in an effort to reach a verdict. You have to look at nuances, you have to really look at details, and you have to work collaboratively and cooperatively and respectfully. And I think that these things are an amazing experience. So increasing opportunities for contact essentially means that you encounter and engage in positive interactions with people who are different from you. This can ameliorate implicit bias through a wide variety of mechanisms, including altering the cognitive representations of the group or by directly improving evaluations of the group. So a lot of the stuff that we see, that we take in, our minds work not unlike computers. They are programmable. And what we put into those is important, and how, in terms of what we get out of them. So why are we even talking about this? I think you all know why, right? We have an obligation to ensure that the people that appear before us feel heard, feel respected, and feel that the person that is hearing them and hearing their case isn't basing a decision based upon these reactions, or this is because this group of people engages in this type of activity, or this religion does this. We have to be able to make sure that the decisions that we make are legitimized. Otherwise, our entire system is called into question. So that's the reason that we are engaged in this work. There are also things that you can do in your everyday practice to ensure that people feel respected, feel seen, and feel heard. We talk about identity a lot. And while race is one form or one way to identify, a lot of times people are going to come and ask you, for example, to use the correct gender pronouns. How they see themselves. If you can't see them as they see themselves, you have just delegitimized the entire institution, because you have to recognize that they see themselves in a certain way. So if they want to be addressed as Mix Galvan, as opposed to Ms. Galvan, or as they, them, she, he, and think about the language that we use when we engage in writing our decisions. And I see this a lot of times even in our jury instructions, when we refer, for example, instead of people by name, we refer to them as the defendant. When we dehumanize them, when we don't allow them the dignity of their own identity and how they see themselves. So this is why we're doing this work, because the places that people come into need to feel welcome for everyone. John Adams famously said, "I cannot expect a perfect institution from imperfect people." He said men, but I say people. And that's true. The institutions are going to be as perfect as the people who comprise them, and none of us are. The only thing we can do is try to do better. And why? Again, legitimacy is added to the decisions that we make. Fundamentally, the rule of law works because we as a community believe that we can resolve these disputes peacefully. And you, as judicial officers, are part of that front line. You know, there's a dispute, it needs to be resolved, and you need to resolve it. But people need to believe that that resolution is based upon being listened to, being heard, and being seen. It promotes trust within the community. It lends for more effective and better advocacy, and it ripples across the justice system as a whole. So how did we get here? You know, we talk a lot about this idea of race as a construct, or frankly, any of those areas, gender as a construct, certainly citizenship as a construct. And we got here in a large way through the law. I like to say that if all of these things are constructs, then the law is necessarily a primary architect, because there's not a single institution, there's not a single agency, there's not a single structure that this courts have not touched in some way, shape, or form, that they've lent the imprimatur of legitimacy to some very racist, classist, sexist ideals. After all, let's start with some of, historically, an example of a case. So as we think about who's responsible, I always say, I don't know, and not me. Well, I'm going to give you an example. Most of us have probably heard of the Dred Scott decision, right? Which essentially the court held that a person who's African American was not even able to apply to the courts for a remedy, that they had no status. They weren't even citizens under the law. And I'd like to say that Dred Scott is no longer a viable case, and certainly as it applies to Black Americans, it's not, because we have the 14th Amendment, right? We fought a whole civil war over these issues. But Dred Scott, that underlying idea of who and who is not a citizen, and who is not entitled to opportunity, has been used. That analytical framework is still in use, and it was as recently as last year when they determined that people from certain territories were not entitled to full citizenship. So for those of you who do not know, we have several territories, such as Guam, such as the Mariana Islands, such as the U.S. Virgin Islands and Puerto Rico, and each of them have different levels, in many instances, of citizenship that is conferred upon them. And a lot of the analytical basis for that is that Dred Scott decision. So in our cases, because we use things such as stare decisis or, res judicata, we perpetuate some of these ideas and notions that we know to be wrong. Here in Washington State, I am happy to say, we are looking at this from a different perspective. And I'm going to talk about some of these issues. I want to talk specifically about the idea of this objective observer standard. Now, I was an administrative law judge for 5 years, and I know many people are thinking, well, that has nothing to do with me, because the objective observer standard arises out of General Rule 37, which governs jury trials. But hold on, I say, because I am reading the tea leaves, and I'm seeing this objective observer standard really come back in terms of not to replace the reasonable person standard, but to add to it. So for those of you who are not aware, the objective observer standard was essentially a reframing of Batson. So our Supreme Court recognized that the Batson rule, which essentially was an effort to ensure that people from BIPOC communities, women, were able to serve on juries without getting unfairly excluded, was insufficient, because all you needed was essentially, quote unquote, a race neutral explanation, and you could exercise a peremptory challenge against a juror of color. So in 2018, our Supreme Court of Washington reframed Batson and created a general rule. And in that general rule, they state that if an objective observer could view race or ethnicity as a factor in the use of a peremptory challenge, the court had to deny the peremptory challenge. More importantly, they went on to describe and define who is an objective observer. And in this, they said that an objective observer is someone who is aware, implicit, institutional, and unconscious bias, as well as purposeful discrimination, have all contributed to the unfair exclusion of jurors. So while I think there was a time, certainly when I was a young attorney, and we talked about issues of diversity, equity, and inclusion, those were done in a kind of a nice to know way. Oh, look at that. We're doing this. Let's pat ourselves on the back. Let's talk about these things. They're really nice to know. Today, this is substantive area of law. It's no longer just nice to know. You're going to need to know. Because as you can see through the next few slides, this idea of what an objective observer is has now gone outside of mere jury selection. And these are very, very recent cases, as you can imagine, because the rule itself is very, very recent. So let's look at one of the first cases that interpreted this idea. First is State versus Tesfacelasier. And in here, it's an issue as to whether or not the court allowed the peremptory challenge of a juror appropriately. And once again, the court reiterated its definition of what an objective observer is. Someone who's aware, again, and we'll go back to that definition, implicit, institutional, and unconscious bias, as well as purposeful discrimination, have contributed to the unfair exclusion of jurors. In this case, the court indicated that the review of this issue would be de novo, and that the parties, again, have the right to a trial process free from discrimination. In State versus Sum, which came out this year, the court applied the objective observer definition to a search and seizure question. Now, this is an extraordinary change in search and seizure law because, as you can see, the seizure inquiry is an objective test in which the seized person has the burden to show that a seizure occurred. So assuming that the seizure occurred, they clarified that a person is seized for purposes of Article 1, Section 7, if based on the totality of the circumstances, an objective observer could conclude that the person was not free to leave. And this is different from before, right? Would a reasonable person conclude that they were not free to leave? So who and what was that reasonable person? And as we think about that, in all the jurisprudence that came before that, we can see that now we're looking at an objective observer could conclude that the person was not free to leave, to refuse a request, or to terminate the encounter due to law enforcement's display of authority or use of physical force. And for purpose of the analysis, again, they defined an objective observer and applied it. An objective observer is aware that implicit, institutional, and unconscious biases, in addition to purposeful discrimination, have resulted in disproportionate police contacts, investigative seizures, and uses of force against Black, Indigenous, and other people of color in Washington. So I want you to think about that. So now we have the objective observer is aware that implicit, institutional, and unconscious biases have led to the unfair exclusion of jurors. And we're moving to the objective observer is aware that implicit, institutional, and unconscious biases have resulted in disproportionate police contacts, investigative seizures, and uses of force against BIPOC individuals. Let's look at another case that just came out 2 weeks ago. This is Henderson versus Thompson. In ruling on a motion for a new civil trial due to racial bias, the ultimate question for the court is whether an objective observer could view race as a factor in the verdict. And an objective observer is one who is aware that implicit institutional and unconscious biases, in addition to purposeful discrimination, have influenced jury verdicts. Why do I think that this is important for you? I think this is important for you because you're going to have situations in which race or an agency action, such as the police action, for example, may come up. And you're going to have to look at how do you define that. Current law is what it is, but you now have this broadening, if you will, of what a reasonable person is and what a reasonable person should know. So in many of these cases, if you go back and you read them, you'll see that there wasn't a lot of discussion about some of these things on the record. And I think that people don't like to be uncomfortable. I think discussions of race, discussions of religion, discussions of gender do tend to make us uncomfortable. But we cannot let our discomfort dictate how we're going to address these issues for the people that come before us. We have to learn to discuss these issues from a legal perspective, from an objective perspective. We're going to have to learn how to frame them, so we're going to have to start getting comfortable being uncomfortable. And part of this training, I hope, is for you to kind of understand how that works for us as humans. We are, again, none of us is perfect, and biases are natural. But how we manage those and how we try to account for them and how we try to be more conscious in how we decide things, I think is important. I'm going to let you ask questions, but I'm going to end, or sort of end, with Justice Sotomayor's dissent in Michigan versus Shuey, because I think she really kind of describes it very well. She says, in my colleague's view, examining the racial impact of legislation only perpetuates racial discrimination. The refusal to accept the stark reality that race matters is regrettable. The way to stop discrimination on the basis of race is to speak openly and candidly on the subject of race, and to apply the Constitution with eyes open to the unfortunate effects of centuries of racial discrimination. As members of the judiciary tasked with intervening to carry out the guarantee of equal protection, we ought not sit back and wish away rather than confront the racial inequality that exists in our society. It is this view that works harm by perpetuating the facile notion that what makes race matter is acknowledging the simple truth that race does matter. Now you can substitute that in for ability, for gender, for citizenship, and understand that where we see these issues play out, it does matter, and we're going to have to learn to address them and to deal with them and to decide whether or not, in many cases, an agency may have acted inappropriately when we're looking at some of these issues. Again, the legitimacy of a legal system, the integrity of the legal system, respect for the rule of law, and how people perceive the courts, including you, because you are a court, matters. It matters to all of us. So I'm going to go ahead and open it up to questions or items for discussion now. And I did want to share as well, and I'll show the PowerPoint. Here's some resources for you to consider. If you have not taken the implicit bias test, I certainly encourage you all to do so. There's a link to the implicit bias test and some items that you can look at that discuss some of these issues and are very helpful as you navigate these waters. Judge Schwartz, anything?
All right. Thank you very much, Judge Govan.
You're welcome. Thank you for having me.